It was also not in contention that the total number of Kericho County Assembly members was 47. The only question was whether 31 members constituted the two-thirds threshold as required by law. In Kericho 2, on the other hand, the question was whether some of the county assembly members alleged to have voted in support of the motion did actually vote. This was a matter requiring evidence to be adduced, including examination and cross-examination of the said county assembly members, and accordingly, this was not a matter that could be determined at a preliminary level without hearing the evidence. Kericho 2 was therefore ruled to belong to the second category of preliminary objection that can only be reasonably subsumed in the full hearing, but for which a determination by the Senate would have to be made at the end before the proceedings to vote on the charges. The question, therefore, is whether the current preliminary objection belongs to the jurisprudence of Kericho 1 or Kericho 2. Now, honorable senators, in the current impeachment proceedings, it is not in contention that there were 19 members in the County Assembly of Nyamira present and voting at the time of impeachment. Secondly, although there is contestation about the validity of the votes purportedly cast by proxy by another 4 members, there is no contestation that the total number of members who voted did not exceed 23 members. The County Assembly, by its own admission, has submitted a list of 23 members as having supported the impeachment. The governor's side, on the other hand, object to this impeachment on the basis that the correct threshold should have been 24 members rather than any lesser number. What is in contention, therefore, is whether the threshold of members required to have voted in the matter is 24 or 23 or lesser number. What is additionally in contention is whether in reckoning the two-thirds threshold, the number of members of the County Assembly is to be applied as 35 or 32. The legal question in contention is whether the number of legislators of the County Assembly remains fixed and unaffected by any vacancies for the purposes of reckoning thresholds, or whether as Councillor Carter Keegan for the County Assembly argues, it is a moving target that cannot be reckoned in advance and depends on the membership of the Assembly at a particular time having subtracted any vacancies existing. Now, honorable senators will appreciate that this is a constitutional and legal questions of the most fundamental ramifications. The decision on which reverberate far and wide and well beyond Nyamira County Assembly, and possibly including this chamber, where at various times and for various reasons we have had vacancies. The decision the Senate takes on this legal question will no doubt bind us going forward in the manner in which we reckon delegations for purposes of voting when there are vacancies in the Senate. From this perspective, it is clear to me that even though a number of matters of fact were raised by the County Assembly in their preliminary objections and fundamental legal questions of threshold, and whether the correct number of delegations that were required to impeach the governor of Nyamira County at the time of the impeachment was undertaken was 24 or 23 or any lesser number is a pure question of law whose determination by the Senate is necessary before these proceedings